found by the decision maker, not really the question of being fit and proper, because what arises is whether that issue had been properly interrogated earlier on. So that's not the emphasis. The emphasis in our application is whether the relevant consideration were taken into account.
Well,
am I correct in that understanding?
We would perhaps make it, we would put the proposition this way. It is a requirement that the person be fit and proper. Whatever other factors may weigh in favor or against a candidate, if they are not fit and proper, they cannot occupy the office. So the question is, do they measure up objectively to the standard of what fitness and propriety requires? If they do not, it's the end of the inquiry. They can, in every other respect, be a glowing candidate. But if they fail in respect of the requirement, because it's an objective statutory requirement of fitness and propriety, then that's the end of the matter. It is not a proper appointment.
Yeah. Well, maybe just clarifying that point. Smelane was a commission of inquiry in which Smelane was subjected to reading evidence and being cross-examined thoroughly. Had that happened to second respondent in this case?
Yes, that is a proposition that is raised by the second respondent, but is ultimately not relevant for the purposes of determining this matter for this reason. The question isn't whether, in that instance, in the case of Similani, it was a commission of inquiry, which is actually not a court of law, and whether a process of cross-examination took place as it did in that instance. But in this instance, it was a question of what had occurred in motion proceedings. The fact of the matter is that what occurred in this case is that there is a final set of findings made by a court of law that was sought to be appealed, and the Supreme Court of Appeal refused leave to appeal. Now, as I shall come to, it is not a case, as is suggested, that Lieutenant General Ntlemeza was denied Audi. In fact, he was given the opportunity to put up all the information that he wished to a court of law, and the court of law, as courts of law do in motion proceedings all the time, make findings. And the court made findings. They are final findings, and in a state where the rule of law governs, those findings are binding and must be respected.
Are we sitting as we are now, bound by the remarks made by?
Yeah. It's a question of, this court is not called upon to reassess the merits of what was found by the court. The question is a different one, which is that a court of law has made a final determination on certain matters. And having made those determinations, the question is, what role do they play in the powers that are then exercised for the purposes of appointment? So it's not a question of whether this court is bound or not. The question is a different one. The question is, what were those charged with making this appointment meant to do with the findings, the dispositive final findings that a court of law has made?
But it's not unusual for you to hear a judge remarking in the case that I do not agree with the findings made by another court.
Yes. That might be so,
So
the Lord.
this court is not bound by the remarks of another court.
Yes, but just to be clear about the inquiry, this court is not sitting on whether the court that made the findings was right or wrong. That's not the issue for this court. This court has a different inquiry to engage upon, which is whether those who were charged with deciding whether to appoint Lieutenant General Ntlemeza could either ignore, as in one version the minister did, the findings of a court of law, or in the other version took, as it were, an exculpatory statement made by Lieutenant General Ntlemeza and gave it complete priority over the findings of a court of law. That's the inquiry for the court. And our proposition is simply this, as was found in Similani, that the findings of, in that case, a judicial, not a judicial commission, a commission of inquiry, is something which a decision maker, such as those who appoint to high office of state, cannot ignore. And anyone who does ignore is acting irrationally. So the test is not whether this court would have come to the same conclusion as Judge Motajani. The question is whether those who were charged with making the appointment could conduct themselves as they did in respect of the definitive findings that the court made. That's the issue for the court.
Seeing that you have taken a point arising from the remarks made by the court, is this court entitled to go and find out whether there was legal or factual justification for those?
In our submission, not, because as with all findings, factual findings of courts of law, those who are subject to them have rights of appeal. They sought, as did the parties to this case, they sought to exercise their rights of appeal. They failed in that effort. And once findings by courts are made, they are definitive and they are binding for the purpose of how they should be considered. So what we read a great deal of from the respondents is special pleading after the event to suggest that the court may or should have come to a different view. Nobody can approach definitive findings of courts of law on the basis of saying, well, I couldn't succeed through the court process of unseating the finding, but I'm nevertheless going to try and appeal to those who are making the appointments to somehow undo or think differently about those findings. Those findings are binding.
What do you think about the remarks about the same remark by Dr. J. in this chapter?
Well, there are two features of what His Lordship Mr. Justice Tookerton said about. Firstly, not most of the burden here is not, it has not, we don't rely for the purposes of this review upon the Boyson judgment at all.
Not Boyson judgment, I mean the severe judgment.
Yes, but in respect of the severe judgment, again, what we say is central to this is that these are findings by a court. And once they are findings by a court, the only question is, how is it possible, and I'm going to come to those findings in a moment, how is it possible that those who are making an appointment process, engaging in an appointment process to high office, would treat these findings by a court of law in the fashion that they did, either to ignore them or to entirely minimize them for the purposes of proceeding with the appointment. In either event, it's an irrational decision, but I'm going to come to that in a moment.
Yes, and maybe when we come to it, consider, and just to follow up to my brother's question, that Captain J does not seem to endorse his brother's findings.
Well, with respect, that's not the correct judgment of what His Lordship Mr. Justice Tookerton found. Your Lordships will recall that Mr. Justice Tookerton found that we had a very strong prima facie case. Now, he could only come to that conclusion because he recognized that the findings of Judge Motajani were such that the conduct of those who engaged in the appointment process was strongly prima facie irrational. He couldn't come to a different conclusion.
You are right. You mentioned that you as advocates that would have a strong case. But then at the same time, as the analysis, you did not endorse the attitude taken by Motajani.
I don't. Ultimately, it will be for this court to make an assessment of what the significance of Judge Motajani's findings are. But what I would ask the court to differentiate two things about His Lordship Mr. Justice Tookerton's judgment. There is the consideration as to the matter that is before this court for final review, which is there a right established? Said His Lordship Mr. Justice Tookerton, there is a strong prima facie right, and we say there is a definitive right which we will seek to establish before the court. His Lordship then went on to consider whether there was irreparable harm that would be suffered in the interim. On that score, His Lordship Mr. Justice Tookerton was not convinced, even though this may prima facie not be a proper appointment, that Lieutenant General Ntlemeza would commit specific acts of harm by continuing in office. That's the burden of what Mr. Justice Tookerton said, but that's not a relevant question for this court because we are now dealing with the merits of the review, not the merits of whether this will be a harmful, whether Lieutenant General Ntlemeza will do harm in his office. That's not relevant to the inquiry.
When the second respondent applied for leave to appeal, was it against the remarks that were made by Mr. David that the order that they made in introducing him differently?
Well, leave to appeal is always sought ultimately against the order, but it's based on the reasons for the order, because although the leave is sought in respect of the order that is made, the basis, the grounds of the appeal rests upon the reasons for the order. And therefore, it is always open to a party, as it was in this instance, to say that matters have been determined in a fashion which not only is wrong on the merits, but imperils my position as a person who has now been criticized in round terms. And those were sought to be appealed, and we know what the disposition of the SCA was on that score. But I'd like to come to the detail of the judgments, because one of the obfuscations in our respectful view is that Lieutenant General Ntlemeza, in the memorandum that he submits, does not actually engage properly with the criticisms that have been made of him by the judge on the merits of the case that were presented before Mr. Justice Motajani. And it's important that one sees precisely what was said of him and why it is that even though he puts up this memorandum, that memorandum doesn't properly begin to engage all the issues that were raised in criticism of Lieutenant General Ntlemeza. And I'd like to take the court to that, because it's very important to appreciate why that special pleading is unavailing. I'm sorry. Yes. If I could just hand to the court, just for your convenience, two sets of cases. The one is the DA case, and the second, again, just for your assistance, is the judgment on the merits that is before the application for leave to appeal was brought in the Sabia case. Now, I wonder whether I might take the court firstly to what was said by the court, turning now to the judgments rendered by His Lordship Mr. Justice Motajani. If I could take the court firstly to the case we've handed to the court, which was the application, which was an urgent application to declare that the suspension of Major General Sabia was unlawful. And that application was brought on an urgent basis. And if I could ask the court to turn up the relevant portions of the judgment, if the court would turn to paragraph 28 of the judgment. So this is the main judgment on the merits of the urgent application, which sought to impugn the conduct of Lieutenant General Ntlemeza in respect of the suspension that had taken place of Major General Sabia. Picking up what the court says in paragraph 28, the third respondent, that is Lieutenant General Ntlemeza, does not explain precisely what applicant's role was in the transgressions. You will recall that this deals with the renditions that were said to take place that were claimed to be unlawful, and how materially different the allegations in the witness statements alleged in his possession is from those already investigated. Third respondent has not attached to his answering affidavit any confirmatory affidavits or documents on which he relies to ground the suspension, despite invitation by applicant to redact the identities of witnesses whose identities he does not wish to reveal. Most importantly, third respondent has failed to identify in terms of which particular provisions he purports to act. On third respondent's own version, and he then deals with the alleged acts of misconduct by the applicant occurred on the 5th of November 2010, and he regards these allegations as very serious. There is no suggestion that applicant hindered or interfered with several investigations that were conducted. The same allegations, and there was that there has neither been a report or complaint that applicant interfered with witnesses since 2010. On the contrary, the indisputable evidence suggests that the applicant was not involved in the illegal rendition of Zimbabwe nationals as alleged or at all. There is therefore no basis for suggesting that applicant's continued presence in the workplace will be prejudicial. So the court deals with the basis upon which the suspension was ordered and finds that there is no basis for it. And then at paragraph 30 says, it is worth mentioning that in paragraph 4 of the said notice of intention to place applicant on precautionary suspension, third respondent states that the investigation for purposes of a disciplinary inquiry are completed, and the only outstanding investigations relate to the criminal aspect. And then he reads out paragraph 4. The Independent Police Investigation Directorate investigated these allegations against members of the DPCI. IPID has submitted its report, prosecution for a decision on the criminal aspects of the matter. The investigation relating to the criminal aspect is still continuing. And then the important passage at paragraph 31. So this is a rendering of a decision on the merits in respect of the conduct of Lieutenant General Ntlemeza, and this is what the court says. In my view, there exists no basis in law or fact for the third respondent to take the drastic measure of placing applicant on precautionary suspension. I agree with the applicant that the decision by the third respondent was taken, and this is the crucial word, in bad faith and for reasons other than those given. It is arbitrary and not rationally connected to the purpose for which it was taken, and accordingly it is unlawful as it violates applicants' constitutional rights. So here you have a rendering by a court on the merits of an application concerning suspension, where Lieutenant General Ntlemeza has exercised extraordinary powers, brought on review, found to have acted in bad faith, and on the basis that the reasons that he gave for his actions could not be accepted, as the court says, for reasons other than those given. Now, if we just step back for a moment and ask this question, in what circumstances would one consider the appointment of a person who is found by a court to have exercised an extraordinary power of suspension and is found by the court to have taken that decision, which is an important power vesting in Lieutenant General Ntlemeza, to have taken that decision in bad faith and presents reasons for doing so which the court cannot accept because they are other than the reasons given. Now, such a person is a person who, at a bare minimum, one would have to scrutinize this with very great care to see whether such a person could conceivably occupy a high office of this kind, because he has already demonstrated the manner in which he discharges his functions in this office. Here is the point that follows from this. This is appealed to the Supreme Court of Appeal, and two judges of the Supreme Court of Appeal find no reason to disturb this outcome at all. So there are now final dispositive findings by a court of law that Lieutenant General Ntlemeza has acted in bad faith and has offered reasons which were not the true reasons for the conduct that he engaged in, which was to suspend another high official in the directorate.
You found this remarks unique in this case. The only case in which you found such.
Well, I'm not certain, regrettably, that it's unique. But what is certainly true is that there is a very large distinction between circumstances in which officials make errors of an administrative kind, which need to be corrected by courts on review because they are sometimes errors of procedure or they are not reasonable decisions. But circumstances in which public officials are found to act in bad faith are happily the exception, not the rule, in review proceedings.
Is it your view that the concept of bad faith is totally inconsistent with having integrity?
Absolutely. No one who is accused
together.
You cannot be a fit and proper person who has integrity for a high office of state if you have been found to have acted in bad faith. They're just entirely inconsistent and cannot be reconciled. Now, we make a very simple proposition which flows from this. There's no complaint, nor can there be, that in respect of these findings there wasn't due process. Lieutenant General Ntlemeza was, like any litigant in a court of law, offered every opportunity to put up the facts in his affidavits. He did so. The court rendered its decision on the basis of the evidence before it, a commonplace feature of motion proceedings in review cases. These are final and definitive decisions by a court of law. They bind not only the parties to the litigation, but they are binding against the world, because that is what the rule of law requires by way of respect for legality and what courts of law do. And this case was not before the interviewing committee, it was not before the minister, it was not before the cabinet, it was not referenced by Lieutenant General Ntlemeza in his...
in the memorandum which he presented to the panel.
Yes.
Towards the end of that memorandum, he offers the case that if it is so required by the panel, it will be made available. And you will check that memorandum.
Yes, what the memorandum says is that, I'm not certain if the court has the review record, but it appears at page 18 of the review record. In the memorandum, and I'm going to come to it in detail, but simply on the point that has been raised, all that is said in paragraph 7 is, it references the judgment of Matajani, and my affidavit are available upon request. But it's not the judgment. It's not the judgment, this judgment, because the judgment that is being referred to is what is referenced in paragraph 3 of the memorandum. In paragraph 3 of the memorandum says Lieutenant General Ntlemeza, to my surprise, when Judge Matajani delivered his judgment on the leave to appeal and the execution application, he attacked me saying that I have accused him of colluding with Sabia's attorneys and so on and so forth.
So your submission is that the main judgment, if you can refer to this as the main judgment, was not referred to?
Not referred to, not provided, and indeed nothing about this was said at all, at any stage in the process.
But is it not so that those remarks that are subject of this letter, they're not made under the meeting?
We submit this point is the end of the matter on any basis, because if one follows the Similani judgment, once there has been a finding, in this case by a court of law, not just by a commission of inquiry of this kind, with such obvious gravity for the question as to whether Lieutenant General Ntlemeza is fit and proper.
Well, these are live pictures that are coming to you from court. The Helen Suzman Foundation's David Unterhalter just arguing there that Lieutenant General Burning Ntlemeza, he acted in bad faith and simply cannot hold a position in high office. That argument continues there. This is earlier this year, the court dismissing the Foundation's interdict application. However, it did give the green light to have his appointment reviewed. And these are the live pictures of that review now taking place.